John Malcolm. He's the vice president for the Institute for Constitutional Government. Really great to have you with us. Can you start by explaining for our international audience the concept of qualified immunity and why even after pressure, we're seeing the court turn down these cases?
Sure. Well, qualified immunity is a judge-made doctrine that says that police officers, other law enforcement officials, can only be held civilly liable when they clearly violate somebody's constitutional rights. And that violation has to be based on clearly established case law. So if there is a case on the books under very, very similar facts in which a court has determined that a police officer went too far and violated somebody's constitutional rights, that officer can be held civilly liable. But if there is not such a case, then the officer is immune from civil liability. They can, of course, still be held criminally responsible, but they can't be sued for money damages.
So, John, why is the court turning these cases down?
Well, the Supreme Court turns down cases for all sorts of reasons, either because the facts aren't clearly presented or, for a whole variety of reasons. The whole idea of qualified immunity is a controversial one. So one, it is judge-made law, which is a little bit unusual. And two, people who are opposed to qualified immunity say that it allows police officers to operate with impunity and that they will get away with it unless there is a case that is almost directly on point. People in favor of qualified immunity say, look, police officers have to make split-second decisions under very, very dangerous circumstances. And unless something is clearly established, you don't want them to hesitate to act when placed in situations like this. And that if you were to eliminate qualified immunity, one, it would be unfair to the police officers to put them in that position. Two, it would lead to problems recruiting and retaining police officers. And also that it would cause officers to hesitate before going into dangerous situations for fear that, hindsight being 2020, they might later be held responsible and subject to a civil lawsuit.
So, John, the court seems to have an issue right now with finding the right way to address this. We have heard comments here and there in the past from justices on the matter. At least we know that at least 7 were turned down today, and at least 3 qualified immunity cases were also turned down by the justices last month. It takes 4 justices to grant a review in these cases. So what are the potential implications? What happens now that the courts have once again rejected these cases?
Well, one, Congress could step in and pass legislation clarifying the standards for qualified immunity. So the courts are not the only place where this matter could be addressed. And also, there are other cases out there. There are always qualified immunity cases that are percolating among the lower courts. So perhaps the Supreme Court will take another case in the future to clarify, perhaps even loosening the standards that currently exist.
All right. John Malcolm, really appreciate your expertise. Thanks for coming on.